Good evening, everyone, and thank you so much for being here to participate in and celebrate with us the ABA Death Penalty Representation Project's Volunteer Recognition and Awards event for 2025. My name is Ted Howard. I am the pro bono partner at Wiley Rhine LLP here in Washington, D.C., and I am currently pleased to serve as the chair of the Death Penalty Representation Project's steering committee. I want to thank all of our law firm sponsors whose names are reflected on the posters here to each side of the screen. And very, very special thanks to Susie Hoffman, my predecessor as chair of the steering committee, and Kroll and Mooring for hosting us in such a lovely fashion this evening. We appreciate it. Tonight, we will hear from ABA President Michelle Behnke. We will honor two law firms, Bradley Arant, Boult and Cummings LLP, and Vorys, Sater, Seymour and Pease LLP, in recognition of their exemplary and outstanding performance in the representation of prisoners condemned to death. We will honor the truly extraordinary Ruth Friedman, which obviously needs no introduction, with the John Paul Stevens Guiding Hand Award for virtually an entire professional lifetime dedicated to the zealous representation of individuals facing the death penalty and advocating for life-changing, life-saving reforms to the capital punishment system. And we will hear from an exceptional keynote speaker, Christina Swarns, Executive Director of the Innocence Project. We hope it'll be an inspirational evening. First, however, I want to spend just a few moments devoting some remarks to the memory of the recently departed Ron Tabak for his many and unparalleled contributions to the mission and work of the Death Penalty Representation Project. When Ron sadly passed away in July, the Death Penalty Representation Project and the capital defense community lost a true stalwart warrior. I would like to thank Don Salzman of the Skadden firm for providing me with the foundation for these remarks, and to Ron's other Skadden colleagues for being here. In 1983, Ron contacted the NAACP Legal Defense Fund, seeking a pro bono civil rights case to handle. LDF's Jack Greenberg told Ron that LDF wanted him to take on an 11th Circuit death penalty appeal. Ron said that Jack's suggestion was ridiculous, quote unquote, because Ron had never argued any appeal of any kind in his life, much less a capital appeal. Jack replied that Ron was, quote, the most qualified lawyer available in the country to represent the client, unquote. Ron agreed to represent death row inmate Raymond Francis, and with the help of talented mentors, Ron argued and won Franklin versus Francis in the 11th Circuit. Then, as Ron put it, the team, quote, eked out a 5-4 win, unquote, in the Supreme Court. It was Ron's first SCOTUS oral argument, but not his last, and he never looked back. Speaking of looking, I'm going to grab my reading glasses. Ron's experience in the Franklin case was the first of many death row cases Ron took on. He became an expert in representing death row inmates with intellectual disabilities. As co-counsel with George Kendall, Ron successfully represented Johnny Lee Gates, an intellectually disabled Georgia death row inmate. They saved Johnny's life in 2003, getting him a life sentence, so that he could live long enough for DNA evidence that proved Johnny's absolute innocence to emerge. In 2020, Johnny was freed and exonerated. Ron also took on the daunting case of Corey Johnson, a federal inmate with an intellectual disability whose federal habeas claims had long before been denied. As many death penalty warriors sadly have experienced for their clients, Ron lost that war when the first Trump administration executed Corey in 2021. But not before Ron and the team gave Corey fierce representation, dignity, kindness, and the gift of reconnecting with his family before the government took his life. In 1983, Ron joined other members of what's now known as the ABA Civil Rights and Social Justice Section to propose an ABA project to recruit, train, and mentor capable pro bono lawyers to represent death row inmates. The ABA created the Death Penalty Representation Project a few years later in 1986. In 2019, when the project honored Ron with its Project Leadership Award for his 30-plus years of remarkable contributions, Ron crafted his remarks using his famous Tabac's Top 10 list format. Ron's 2019 remarks are on the project's website and are worth viewing and listening to. Number 3 on Ron's top 10 list that night was, quote, "If you suggest something, expect to have to do it," unquote. Ron played a central role in the project since its creation because Ron was a never-ending font of creative suggestions and ideas. True to his top 10 list, number 3 credo, Ron then volunteered to lead many coalitions to bring his valuable ideas to fruition. Ron made too many contributions to mention them all this evening, but here are a few. Ron played a key role in efforts that culminated with the ABA issuing a statement calling for a moratorium on the death penalty. In addition to expertise on intellectual disability, Ron also became an expert on mental health and the death penalty. Using his expertise, Ron deftly navigated institutional rivalries between the American Psychological Association and the American Psychiatric Association to get both organizations to join the ABA in advocating that certain people with severe mental illness should be exempt from the death penalty. Ron was a prolific writer who relentlessly advocated against the death penalty on practical, legal, moral, and religious grounds in Supreme Court and other amicus briefs, book chapters, law review articles, opinion pieces, and guest sermons at religious institutions. Among Ron's most notable death penalty publications, he submitted a comprehensive chapter on the death penalty to the ABA's annual volume on the state of criminal justice, beginning in 2007 and every year since. Beyond the world of capital defense, Ron was an unparalleled ticket scalper. Of course, in only the best and purely legal sense of that concept. StubHub, Ticketmaster, and SeatGeek had nothing on Ron Tabak. But unlike commercial ticket scalpers, Ron's, quote, markup, unquote, on ticket sales was devoted exclusively to donations to worthy charities, amounting to thousands of dollars over decades to myriad worthy causes. Finally, Ron was a huge baseball fan. Born a Yankee fan in 1948, Ron also became a Mets fan when that team joined the National League in 1962. Hall of Famer Yogi Berra, who played for both teams, famously said, quote, "When you come to a fork in the road, take it," unquote. Ron lived that advice to the fullest. He took the fork to represent death row inmates and to devote every ounce of his talents, effort, and energy to advocate for death penalty reform and abolition, and to recruit and train and inspire a generation of capital defenders and pro bono lawyers for death row inmates, all the while making a profound contribution to a path towards greater compassion, humanity, and justice. Ron, you are sorely missed in person, but we are sure that you are with us here in spirit. Please join me in giving that spirit a rousing round of applause. Thank you all. It's now my honor to introduce the new president of the ABA, Michelle Behnke, who has taken time from what is no doubt an already frantic schedule to extend her greetings to this gathering.
Hello, I'm Michelle Behnke, President of the American Bar Association. Thank you for joining us for the ABA Death Penalty Representation Project's 2025 Volunteer Recognition and Awards event. I wish I could be with you in person to let you know just how much the ABA appreciates the heroic work of our volunteers and staff made possible by your critical support. We are all aware of the threats faced by our legal and justice system, from government officials who persistently threaten to remove judges just because they don't agree with their rulings, to undermining of law firms and lawyers who have taken on clients and causes the government finds objectionable. The American Bar Association's voice has been strong and unequivocal in our system of accountability under the law. Such actions must never prevail. We will always insist on maintaining our independent judiciary that reaches decisions on the facts and the law, independent of politics. And we will always insist that lawyers be free to represent clients of their choosing and all parties be represented. And we will always insist on following our core tenet, equal justice under law. Death penalty cases can be especially challenging for the lawyers who work on them. The ABA proudly stands with the pro bono volunteers who have joined us in this highly specialized area of law. We are particularly pleased to recognize two exceptional pro bono law firms, Bradley, Arant, Boult, Cummings, LLC, and Vorys. We are proud to present this year's John Paul Stevens Guiding Hand of Counsel Award to capital defender Ruth Friedman, who has dedicated her career to providing exceptional representation in capital cases. Our honorees and other lawyers who provide pro bono death penalty representation demonstrate exceptional courage in the face of harrowing and fierce opposition. This brings to mind the signers of the Declaration of Independence almost 250 years ago. Did you know that 25 of those 56 signers were lawyers? These lawyers, committed to the rule of law and not the rule of kings, demonstrated our profession's trademark leadership and public service. Stay tuned in the coming year for events from the ABA to celebrate the 250th anniversary of the Declaration of Independence and the contribution of lawyers brought to this sacred cause. Again, thank you for your support and for your demanding, essential work. My best wishes to all of you for continued excellence in service on behalf of the rule of law.
Thank you so much, President Behnke. I would now like to invite J.S. Christie to the podium to introduce our first law firm honoree.
ABA Death Penalty Representation Project Award event attendees, good evening. My name is Chris Christie. I'm with Denton Sorority. I've been there 8 years, and I nominated Bradley for this award. I want to recognize Brad Robertson, Lindsay Boney, Tiffany Graves, who are here from Bradley this evening. And I want to thank the Sidley firm and EJI as being the other entities that recommended Bradley and gave a letter of recommendation. In the last 4 decades, Bradley has represented 39 inmates on death row. 31 of those were inmates in Alabama. And Bradley's largest office is in Alabama. About 1/3 of the firm is in Alabama. The Bradley firm was awarded in 2012 this same award. So this is the second time Bradley's been recognized. And at the time in 2012, Bradley had 27 inmates that it had represented. 2 had died of causes other than being executed. 1 had been removed from the death row and be resentenced. 1 had been exonerated. And then 4 had died of other causes. Since that time, right, Bradley has now had 39 total inmates represented. The additional inmates, death row inmates, have been in a number of different states. Of those, 4 have died of other causes, 8 have been executed. In 2024, there were 31 Bradley Arant attorneys who worked on death penalty cases on behalf of 21 different clients for over 1,300 hours in the year 2024 only. Today, there are 19 death row inmate clients, and that's because in 2024, 2 of Bradley's clients were executed using the never used before anywhere besides Alabama, nitrogen hypoxia method of execution. Kenneth Eugene Smith was executed in January 2024, and Alan Eugene Miller was executed in September 2024, both of whom were Bradley clients. Brad Robertson actually was one of the lawyers representing Mr. Miller. The other Bradley clients have been executed: James Edward Barber in July 2023, Keith Gavin in July 2024, John M. Nixon in December 2005, the only one of the executed who was executed before Bradley was given the award in 2012, Dominic Haken Marcel Ray in February 2019, Matthew Reeves in January 2022, and Willie B. Smith was executed in October 2021. You know, by saying these men's names, it makes you realize they're people, they're persons. And if you're a person who is a person of faith, right, recognize that each of these is a child of God. Each one of these men was created in God's image, and what our society has done to them. Charles Mammon Jr. is the newest Bradley death row inmate client, and he is a possible innocence arguments. Most of the others, frankly, were people who, didn't have arguments about innocence, but frankly, had been provided inadequate representation. I can tell you that in Alabama, almost none of the death row inmates had adequate representation, especially during the penalty phase. And Alabama is the only state that provides 0 representation post-conviction for the people on death row. Alabama has twice as many people on death row per person as the next highest state, which is Florida, and third is Texas. Alabama is just a difficult place for people who have ended up on the wrong side of the law. I hope that my comments have not been a Debbie Downer type of comments, but I do think that you can recognize the exceptional work that Bradley Arant has done. And I think that especially if you focus on the work that they've done since 2012, I don't think there's a firm in the United States that compare. Thank you.
Thank you, Chris, for that introduction. And thank you, ABA, on behalf of Bradley Arant, Boult Cummings. We are humbled by this honor tonight. You know, we don't do this work for the accolades, but it sure is nice every now and then to get something. I'm Brad Robertson. I'm a partner at Bradley, and I'm the co-chair of the firm's pro bono committee, along with Tiffany Graves, who's also here with us tonight. If you're not familiar with Bradley, we're 700 lawyers across the Southeast. We have our origins, as Chris mentioned, in the state of Alabama. That's where we first got involved in death penalty representation. That's still where we do the most work, even though we're making efforts to expand across the Southeast. Personally, I first got interested in death penalty representation in law school. I went to a lunch event and Brian Stevenson was the speaker. And it was from Brian that day that I learned that my state was the only state where we both elect our judges and have what's called judicial override, which is where a judge can disregard a jury's recommendation of life in prison and impose a death sentence. So you can imagine what kind of shenanigans happen when you pair that with elected judges. As Chris said, we're also the state with the highest per capita rate of death sentences in the country. I learned that that day at lunch as well. Learned that Alabama has no statewide public defender system. And until 2017, there was no state-funded mechanism for post-conviction counsel. We actually have since gotten rid of judicial override, which is great, but there are still a lot of people on death row who are there because of an override. And there now are some funds for post-conviction counsel, even though it's really, it's not enough. They're very meager. So I heard the call that day at lunch, and at Bradley, they heard the call as well. Over 40 years, we've represented death row inmates. There have been 39 inmates, as Chris said. As far as we can tell, there have been 262 Bradley lawyers over that period that have billed time to death row clients. We've logged tens of thousands of hours in these cases over the years. We take the lead on some cases, and there are a lot of cases where we're active and engaged local counsel, where other firms who want to leverage their resources and do work in Alabama can use us as local counsel, and we help them along the way. We also partner with fantastic organizations like the ABA's Death Penalty Representation Project, like the Innocence Project, and like EJI. Chris mentioned some of our successes over the years. We have had 5 clients removed from death row, 4 passed away in prison before they could be executed, which is not a win, but it's kind of a win. You know, those gentlemen lived their lives and they were never taken into that execution chamber. And you know, I put that in the win column. And one gentleman several years ago who was fully exonerated and is now a free man. And I want to talk a little bit more about him. He's pictured here with his hand over his heart, Clemente Aguirre. My partner, Lindsay Boney, who's here tonight, represented Clemente in that case. Clemente was exonerated of all charges after 14 years in prison on Florida's death row. In his case, the DNA evidence exculpated him entirely and implicated another suspect. There were 150 blood swabs at the crime scene. And when we got them tested, none of them matched with Clemente. And in fact, there were 8 of them that didn't match with Clemente or either of the victims. Come to find out, they did match with one of the victims, with the victim's family member. A victim's family member who was known to have mental health issues and to have conflict with the 2 victims. Digging further, that family member had actually confessed to the murder multiple times, almost a dozen times. So with that evidence in hand, the Florida Supreme Court, we took the case, the Florida Supreme Court overturned the conviction and the death sentence. And this is the moment when Clemente learned. This is why we do the work. Everyone just needs to soak up that picture for a moment. That's the moment he learned that he was going to be exonerated after so many years falsely accused on Florida's death row. But with all of that, the most striking fact is how many resources went in to getting to that point. The state's case was all circumstantial. I've recounted to you the evidence in his favor, and yet he was on death row for 14 years. Bradley put over 10,000 hours into his case. And that's just Bradley's time. We partnered with other firms. There were local Florida lawyers involved as well, and the Innocence Project. We spent over $200,000 in costs and expenses over the course of all of that to get one innocent man freed in a case where the evidence was frankly overwhelming that he didn't do it. And not all cases are like that. It's just astounding that it takes resources like that to achieve justice for someone. That's why it's important that we continue doing this work. Justice can be elusive. Justice can be expensive. There are times when the barriers to justice can seem insurmountable, but with dedication and with good lawyering, it can be achieved. You know, as Chris was talking about in his comments, doing the work involves hard times too. We represented 2 individuals executed recently in Alabama by nitrogen hypoxia. My client, Alan Miller, and my colleague, Andy Johnson's client, Kenny Smith. There were 2 very different men who had very similar experiences at the end of their lives. Both of these men exhausted their post-conviction appeals. We filed 1983 actions on behalf of both of them to defend their constitutional rights at the end, and both were taken to the execution chamber to be executed by lethal injection. Both of them survived their lethal injection. They were both botched lethal injections. They were taken into the execution chamber. They were strapped down to the gurney, and they were poked and poked and poked and poked. You have to set 2 IV lines under Alabama's protocol to proceed with lethal injection, and they couldn't tap 2 veins. They were poked in the arms, they were poked in the hands, they were poked in the feet, they were poked in the neck. And eventually, when it got close to midnight, the state's death warrant expired, and they couldn't legally execute these prisoners after midnight. So they were unstrapped from their gurneys after this hellacious experience and taken back to their cells. Both men suffered horrendous PTSD because of that experience. We filed new 1983 actions for both of them. But as we've already said, they became the first 2 men executed in the country by nitrogen hypoxia, strapped down to the gurney again, and died gasping for air. As too many of us know, there's a humbling professional and emotional whiplash on execution days. It's when the work of a defense lawyer comes to a crescendo, filing last-minute briefs. And then all of a sudden, the client you've been working so hard to defend, in a flash, isn't there anymore. It's a sad truth of the work that we do, and it's one that our firm has unfortunately had to experience numerous times. Well, this work doesn't come with many happy endings, but this speech really should, right? So let me tell you about what we're working on now. Bradley's working, as I said, to expand our death penalty representation beyond Alabama. We're purposely looking for cases in other states within our southeastern footprint. I told you about Clemente in Florida. We also recently represented Todd Zomer in Florida. We successfully got him resentenced to life without parole after the Supreme Court's ruling in Hearst. We represent the only woman on Mississippi's death row. And we recently took on a case with the ABA Death Penalty Representation Project of a client in Texas out of our Dallas and Houston offices. Hopefully that's the first of many Texas cases that we take on. We're also actively looking for cases in Georgia for the lawyers in our new Atlanta office. So thank you all again. This award tonight is for all of our attorneys who ever recorded any time to revising a 150-page post-conviction petition, or to listening to endless jailhouse recordings, to finding and interviewing family members, to tracking down old teachers and neighbors and pastors, to subpoenaing old school and medical records, or just for picking up the phone for a client who needed someone to talk to. On behalf of all of us at Bradley, thank you very much.
I'm gonna take two. Okay. 3, 2, 1. One more. 3, 2, 1.
Thank you again for letting us know what goes into all of the work that is for which an award like this is a small measure and small consolation, but well warranted and well justified. I'd now like to call on Carol Wright, who will introduce the evening's second law firm honoree.
Thank you. It's really an honor for me to be here to introduce the lawyers at Vorys. 30 years ago, I was a sole practitioner. A friend from the state public defender's office called and asked if I would take on a state post-conviction case, capital case. And I naively said yes. A couple of days later, 26 banker boxes arrived, and I didn't know what I was going to do. I was fortunate enough to know a partner at Vorys, Jim Phillips. He's no longer with us. He agreed to co-counsel the case. I didn't exactly know what that was going to mean either. But what it meant was all of a sudden I had an entire team. Jim Phillips assigned associates, a paralegal, a legal assistant, and threw resources at the case. My 26 boxes were OCR'd. They were organized. I got summation, which shows how old I am. I didn't even know what that program was. They provided it to me. And the partners didn't just check off their pro bono service. They actually worked the case. Jim Phillips interviewed witnesses. He prepared for hearings. He called the trial attorney. He visited the client on death row. So all of a sudden we had all these resources and this commitment to excellence that Vorys brings to the case. So I thought, great. Of course, what happened? We lost, because that's what you do in state post-conviction. You lose. And we lost again, and we lost again. Fast forward 15 years, and we're in federal habeas at this point. Vorys is still co-counseling. They have a room devoted to the Myers case. A good federal judge granted DNA testing, which was exculpatory. We went back into state court and ended up having an evidentiary hearing on a motion for new trial. Elizabeth Smith, a partner now at Vorys, took over that evidentiary hearing, and along with Chris LaRocco, they helped the FPD attorneys present this very intensive hearing. 8 experts, 2 weeks, and they didn't just present the evidence. They learned it. They spent thousands of hours preparing for it, and they mentored these young federal public defender attorneys. They don't just invest in clients, they also invested in the team. And that team grew so much as a result of that. This wasn't a one-off. Oh, well, first of all, let me give you the good news, which is that court, that judge granted a new trial. He vacated the conviction. It's up on appeal now, but fingers crossed. David Myers is out. He has been out since last August. He's working, he's with his family, he's doing great. He attended his own oral argument on Tuesday. But again, this wasn't a one-off. We reached out to Vorys again 5 years ago when Elwood Jones, a man who had been convicted 25 years ago based on a lot of junk science and a lot of prosecutorial misconduct, ended up getting a hearing on a motion for a new trial. The sole practitioner that was involved in that case, along with the federal public defender attorneys, knew they needed help. It was going to be a very extensive hearing. And that's when they turned to Vorys in Cincinnati, a branch in Cincinnati, and David Hine and Emily St. Cyr got involved in that case. And with a very short time frame, they agreed to take on and present this evidence. Now, the pandemic helped extend that timeline. And that gave them even more time to visit the client, to know the case, to learn the experts. And they did all of that. Elwood Jones was granted a new trial. The prosecutor is still vigorously fighting against that. But Vorys has stayed with it. They've argued in the First District Court of Appeals on a couple of occasions, and just recently in the Supreme Court of Ohio. Fingers crossed on that one too. What I learned as a result of this was that Vorys is a client-centered, their representation is client-centered, but it's not just that, it's also team-centered. They have mentored a lot of young associates, a lot of young attorneys. They have helped immensely in Ohio's death penalty work. So I'm really pleased to introduce Elizabeth Smith, David Hine, Chris LaRocco, Emily St. Cyr, and I know they're going to throw a lot of other names because, of course, this is not just a couple of attorneys. It's a team effort. Thank you.
Well, good evening, and I am Elizabeth Smith, and I have to tell you that I am extremely humbled to be here amongst all of you who really toil and have toiled daily in this arena. We don't. We are a civil defense law firm of almost 400 lawyers. I don't know criminal law, or at least I didn't. Now I know a little bit of it. I still don't understand the habeas process, but I have been told that's a very hard process to understand. So again, so very humbled to be here. This really has, as Carol has indicated, a long history, and there have been a number of folks who've been very involved with it, even those 30 years. Jim Phillips, when he started working on this 30 years ago, I had no idea that he was doing this, but that was the way Jim was. He was very modest. And we did not have a lot to do with it in the intervening years after the post-conviction was lost and it went into federal court. Though I would say that during that time, Chris and I were successful in getting treatment for Mr. Myers for hepatitis C, getting him expensive Harvoni treatment, which at the time was very unusual. My husband, who is a physician, said, "How did you get that for him? I can't get that for my own patients." But, I'd like to say that, we argued that it was to save his life. Think about the irony in that, right? So, a number of years later, as Carol indicated, I got a phone call, and then I was followed up by some very heavy briefs, heavy by email standards, and told that these were going to be filed, these needed to be filed in about 3 days. And I had some intermittent conversations with Carol over the years, but I really did not know at this point in time what this case was all about. In fact, when we had worked on the treatment, I said, I don't need to know what this is about. I just need to know that we need to do justice for this man. I don't need to know the underlying facts. I didn't at that time want to know them. Well, so we find out that now a motion for new trial and a petition is being filed to vacate the sentence. And I knew nothing about it. And I'm like, well, I can't put my name on these pleadings without at least doing a little bit of work here. So I had like a day or so. So I looked through it and I added a couple comments about maybe making it clearer or whatever, but understood at the time that it was going to be amended and that there would be another opportunity. So we let it, I felt ethically I could sign the pleadings, sign the briefs, and off it went. At that point in time, we then invited the public defender team in. Chris LaRocco is on the team. We brought in then a first-year associate, Max King, and we also brought in Kim Lewis, who is a paralegal, who had worked on this case 30 years ago, knew that case inside and out. If I said, where was this in the transcript, she found it like that. And my admin, who also, Denise Gant, who had worked with Jim Phillips and now was working with me. And those two women, Kim Lewis and Denise Gant, who had lived with this case for 30 years, I have to say were really a driving force in this. They're the ones who said, Miss David Myers is innocent. This is a terrible case. You have to work on this. Okay, I didn't need much convincing. And so we got to work. I am so grateful. We're all so grateful to the firm for letting us do this, take the time. It happened for me to fall at a very important time. I was just about a year and a half away from retirement. I had finished up some big cases, so we had the time. So the federal public defenders were incredible. They were the ones who got the experts together. We went to hearing with, again, 8 experts, 4 of them, I want to say, I think 4 of them were DNA experts. But this was really, it really became a textbook case on junk science, old science. We attacked the hair microscopy. We attacked the finger, what would you call it? Printing, not fingerprinting, but the finger markings, all of that science. It was a textbook case. We attacked it all in order to make sure that the judge understood that there was indeed a strong probability that at least one juror would find that David Myers had not committed this crime. The DNA technology, of course, has progressed so far, as you all know. The state would not admit and did not admit until this week that the DNA evidence was new evidence. I have no idea how they couldn't admit it, and I think it made them very incredible. They put on one witness, who was the head of the Bureau of Criminal Identification and Investigation, and essentially argued the case. But their expert could not say, his mantra was, there wasn't enough DNA evidence, according to their standards, to reach the results that our experts had reached. And he could neither include nor exclude David Myers. Of course, we jumped all over the fact that he could not include David Myers in this. And so this case came down to essentially the fact that there wasn't even an eyewitness to the crime, okay? There was, in our view, no evidence to link David Myers to this crime. There was one witness who had seen him earlier with the victim, et cetera. So, but T.C. Tansky and Julia Roberts from the Federal Public Defender's Office were incredible, but again, they worked with us, they developed the experts, and then everybody on the team had an opportunity to present at the hearing. And I think the judge was very impressed by the fact that everybody had a say in this. So again, one little antidote, which I thought, something I observed. When we walked into the courthouse the first day, I guess I would say it this way, we were treated rather abruptly by the sheriff and the deputy sheriffs. You know, we come in with our team and all the stuff. And it was clearly very chilly, and if they could not have liked us, they didn't like us. So, but what was fascinating is at the end of 10 days of hearing, they treated us so differently. They treated us with respect. And it was heartwarming to see that even on them, perhaps, that the evidence, the arguments had an impact. And so I felt, I'm thinking this is good. This is good. So this is not, this is not about us. This is about all of you who toil. And there is nothing more important than the work that you do. And that's why we did what we do. There is nothing, I think, more important that a lawyer can do. And frankly, we have to remember that justice is justice for all. It's not for Republicans. It's not for Democrats. It's not for the rich. It's not for the poor. It's not whether you're liberal or conservative or black or white. It's for all. And justice for all. There's a reason why our pledge says that. It is justice for all. Thank you for all that you do in ensuring that justice is for all. Thank you.
I'll try to keep this short since we're double dipping here. My name is David Hine, and as was said, for the past 5 or 6 years, my partner, Emily St. Cyr, and I have represented a gentleman named Elwood Jones. Elwood spent about 27 and a half years on death row for a crime that he had no part in. In 1996, he was convicted of murdering a woman in the hotel where he worked, but that conviction was only obtained through a series of misrepresentations and omissions on the part of the prosecutors and the police officers that resulted in thousands of pages of exculpatory and impeaching documents, critical scientific evidence, and even the apparent admission of another suspect, all being withheld from Elwood and his team and the jury. Now, fortunately, in December of 2022, we were able to convince the court to vacate that conviction. And the following month, Elwood was released on bond and walked out of prison and into the arms of his family for the first time in nearly 3 decades. About the same time, the prosecutors, the same people who were responsible for the trial in 1996, the same people who withheld the information, pledged publicly to pursue Elwood until the ends of the earth. And instead of engaging in any kind of honest evaluation of the evidence, instead of looking at their own conduct, they have stayed true to their word and have appealed everything that they can appeal and some things that they can't appeal for the past 3 years. Now, I'm very proud to say that they have lost at every step of that process so far. But the thing is, Elwood is 73 years old, and he is still living this nightmare, and we are still doing everything we can to bring it to a close. And I want to stop there for a second and say that if anybody has questions about this case, or if anybody is curious about what, if anything, they can do to help Elwood, and there are things you can do, Emily and I are here and are happy to talk to you at the end. But I want to use the rest of my time real quick to talk about not what we've done or are doing, but instead how and why we've been able to do those things. And it is simply this. Our firm, Vorys, Sater, Seymour, and Pease, has given Emily and me absolutely unconditional support for the past 6 years. And that sounds simple, but as these cases are, it's been an extraordinary amount of work that's gone from the trial court to the Court of Appeals to the Supreme Court and back. Sometimes we've been in all 3 courts at the same time. But more than that, it has been a very public and at times a very political case. And I know as a matter of fact that there are other firms in our community that are good and reputable firms with good and talented lawyers that would have caved to the pressure that has been applied on Vorys thus far. And I am so genuinely proud of the fact that Vorys has not blinked once. For 6 years, Emily and I have been given the free rein to use whatever time and resources we need to see that Elwood gets the justice that he is owed. And we have always known that we work for a good firm with good people. But if you can tell, it is at times, honestly, a little overwhelming to think about the support that we have had. And it has been difficult in the past few years to try to convey to our partners and our colleagues what their support has meant to us, which is why this genuinely means so much to me and Emily, because it is a very public pronouncement of the extraordinary commitment to justice that Vorys has made in our case, in Elizabeth's and Chris's, and just genuinely. So one more time on behalf of me and Emily, I will say to my partners and colleagues, thank you. And to everybody here and at the ABA, I will say on behalf of Vorys, thank you very much for this award.
Three, two, one. Perfect. One more. Three, two, one.
Congratulations to Vorys, and can we have one more round of applause for both Bradley Arant and it's now my great privilege to ask someone who literally needs no introduction to this audience to come forward to present the John Paul Stevens Guiding Hand Award, Mr. Stephen Wright.
Good evening, everyone. It's a great pleasure and honor for me to give this John Paul Stevens Guiding Hand of Counsel Award to my colleague, my friend, a person whose brilliance I've admired for 40 or some odd years, Ruth Friedman. As has been noted earlier, Ruth Friedman devoted every moment of her career to representing people facing the death penalty in the state courts and in the federal courts. Even when she was a law student, she came to the Southern Center for Human Rights one summer as an intern. And I said, we've got to get her back because when you have someone that extraordinarily talented, who can do anything and who can go anywhere, we have got to have her back. When we celebrated her at Yale Law School back a couple of months ago, I said to the students there, she didn't even go to a clerkship. She came straight to the Southern Center for Human Rights to represent people in the state courts, the trial courts. We did a trial together. She represented people in state post-conviction, mostly in Georgia and Alabama, but also in other places. You know, one little poetic moment of poetic justice, Ruth probably would prefer I not include it, but I just want to say that when you heard earlier today about Judge Override in Alabama, and when Ruth Friedman took on Judge Override on behalf of Louise Harris, and she took it all the way to the Supreme Court of the United States, and she got one vote. John Paul Stevens. And the dissent that he wrote, like the brief that she wrote, and the argument that she made, were on the right side of history. And you look today, and even Alabama doesn't have Judge Override anymore. Nobody has Judge Override anymore. But we took that, there's so many things, and along the way, while she was there with us at the Southern Center for Human Rights, she helped bring in to existence the Equal Justice Initiative. For some time, she was back and forth dividing her time between Alabama and Georgia. And then, of course, in 2006, she took on the Federal Habeas Representation Project, a new project which she took on and handled the whole time until just a very, very short time ago. And of course, we all know and we celebrate the great success in winning clemency for 37 people on the federal death row. But back at the time that that fight was being fought, back at the time that it was being planned by Ruth and others, and back at the time that all the energy and everything was going into it, there was no guarantees of how it's going to come out. All that work could have been for nothing. But all of it, as you look back at that time, it was a whole different world, a whole different world. It was a whole different world, wasn't it? But thank goodness it was, so that those people were moved to safe passage and they're not executed by the current administration. I can't think of anybody who is a better example of a person whose life has been lived in the guiding hand of counsel of those facing the death penalty. And so, Ruth, I'm honored to ask you to come up and receive this award. I don't know what happened, but no, they gave you the smallest reward. I don't know why.
Did you hear that?
Maybe
I got
because it was last. Congratulations.
Well, try not to break this while I'm up here. Well, that was nice. Okay, so I could talk just a little bit differently. When I was a young person, before any of this stuff happened, nobody would have accused me of being particularly optimistic or very hopeful kind of human being. I was a majorly disgruntled teenager. I dropped out of college for a very long period. And when I got to law school, I thought, oh my God, I have made the biggest, most expensive mistake of my life, which I may not have been alone in that thought. I don't know. When I graduated, and you know this, and I graduated and told my parents that I had decided to work with people facing the electric chair, and in Georgia, no less. My mother was like, "Oi, we knew you'd do something like this." And that's true. And because they envisioned, aside from penury, they envisioned, a career of despair and impossibility. But they were so wrong, because if you think about it, what legal endeavor is more imbued with hope than what we do? I mean, we represent the most despised people in the country, or among them, all from marginalized groups, mostly Black and brown, uniformly poor. And even though it's legal work, it's so politicized, so that you have elected judges like we do in Alabama, and governors and even presidents now running on how many people they want to execute. You got to have some level of hope to do that kind of stuff. So we do it because it's the right thing to do. But we do it too because we believe that we can help people, that we can help these men and women. We assemble a team of smart lawyers, we pour through lots of records and documents, and we look and hope that we can find the kernel of something that's going to get them a new trial or get them off of death row. And sometimes we do. Sometimes, despite years, for example, of lying about it, you find that a government agency did in fact find your client mentally retarded, intellectually disabled 30 years ago, as Angie and Jean's office, the Indiana Federal Public Defender, and Dorsey and Whitney found. Or you find that a juror has been lying through his teeth, including to the judge, going out and doing his own investigation so he can get somebody convicted, as Kathleen Price, the incomparable Kathleen Price, and Clara Gottlieb found. Or you find after someone has spent 3 decades on death row, you prove to a court finally that someone else did the crime and that he's innocent, as George Kendall of Squire Sanders, Squire Patton Boggs, and the NAACP Legal Defense Fund, and our wonderful Christina has as well.
in Alabama. And of course, that's going to be facing all kinds of appeals. I mean, where other people see a, no possibility, you saw possibility. And that's true, obviously, for the Bradley Arant lawyers who have taken cases in Florida and Alabama, the worst, hardest districts in the country. Vorys getting men off of death row in Ohio. Carl and Morning too. Thank you for all that you've done. You know that you might lose, but you think that maybe you won't. So sometimes some of us just had to dream big because we really had no other option whatsoever. Many of us in this room represented people at the very end of the road. This is where we were in the federal death penalty system a few years ago. We had a lot of guys out of court and the rest of them moving up there to join them. We knew that even if the Biden administration continued to not execute people, and let me tell you, we were very thankful for that, it would move on in a few years and it could be replaced by a very different kind of administration. And that could be a bloodbath. Because we had seen this scenario before, as I know many of you know. The Obama administration didn't execute, that was terrific. But when it left, a new administration eager to do something very different came in, and the federal government executed 13 people in 2020 to 2021 in the middle of COVID, twice as many people as the rest of the country combined. These included 2 men who were intellectually disabled. One was Don Salzman's client, and Ron Tabak also worked on that case. A man and a woman who were so intellectually, so mentally ill that at the end they didn't really know why they were being executed, but they couldn't get into court to have a hearing on their competency. It included 2 prisoners for whom the government, the US government, had lied to get their death sentences and put on false evidence. But they couldn't get back into court. One of those, the first prisoner executed was our client, our office's client, Danny Lee. His previous counsel, we took the case at the very end, didn't understand habeas, and he left winning issues on the table, which for those of us who do this work is really, really painful to have to live with. It's a case where the government told the jury he had committed another murder, which he had not. It's a case where the victim's family, the lead prosecutor, and the judge all said at the time of execution, when he had a date, that he shouldn't be executed, that he should be given clemency. But that didn't make a difference. We saw too with Danny and with all 13 that the Supreme Court turned a blind eye to all of it, despite novel issues that couldn't have been brought any earlier, despite 22 stays of execution brought by the lower courts. We did not want to see this happen again. So we thought big because we really had no opportunity to do anything else. Grants of clemency are rare. Mass grants are rarer. But what options do we have? We started early. We put together stories and data about what was wrong with the federal death penalty. Everybody saw it as the gold standard, but even though people got paid, it had all the same kind of problems as the states do. Indicia of racial bias, all white juries, prosecutors who called our clients wolves and animals, well-paid lawyers who missed intellectual disability somehow, or evidence of schizophrenia. We enlisted all kinds of groups to help push these facts, from legacy civil rights groups to the Innocence Project to the Catholic Church. We had White House whispers and Catholic Church whispers. I don't know, is that heretical to say? I don't know. I don't think so. These were extraordinary people. I had on my office door for a long time a picture of the head of Catholic Mobilizing Network handing the Pope a note which said, clear federal death row. Next to the picture of her talking to President Biden. I personally reached out to people in this room to help, and nobody said no. There was no roadmap. We didn't know what we were doing. And yet, deep down, we thought something was possible, right? Because we kept going. Because really, if not, our guys were lost. Shockingly, we succeeded, at least mostly succeeded. And as my friend George Kendall likes to say, it took one big village. Some of those villages are here. I'm going to point out Catherine Huffman of the Raven Group, without which she got the White House to listen. And, maybe if you get her drunk, she'll tell you the stories, but I don't think so. Laura Burstein, who knows better than anybody in this world how to shape our stories, how to get them out there. The incomparable NAACP Legal Defense Fund, who from the very beginning, throughout until the end, were with us in every way there was to be. Many thanks, Demetria McCain and Christie Rock. All those folks worked with us for years, years and years. Not because we knew what was going to happen, but because we just kept trying, amassing evidence and getting ready for what we needed to do. There's Robin Marr at DPI, who got it out to the media. Sarah Gannett, who couldn't be here, who was a part of this village, a true behind the scenes magician, as were Jean Giles and Angie Ellman, who are here. They do extraordinary work with clients, and one day you guys are going to be up here, for sure. It was a joy for me to collaborate, to rely on my stalwart colleagues, and to meet new ones. We were working together on something that might never happen. It was a thrill when he commuted those 37. It was an absolute thrill. I mean, wow. Who could believe we were right to hope and to try? So what I really want to say is that we're now in need of so much more of that kind of hope. And we're in for a much bigger fight. We see our world changing in very, very dangerous ways. Law firms are being blackmailed. Universities have their research grants stripped. Nonprofits are having to close their door. Public defenders are hemorrhaging staff while our prosecutions are growing and growing. Groups that support civil rights and represent the poor are being themselves directly targeted by our government. The ABA Death Penalty Project that welcomed us here today is at risk of losing some of their staff. All of that will hurt most, as is always the case, the very men and women that we represent. We can't ignore the obvious attempt to whitewash our history, the painful past of racial violence at the same time that it informs our capital punishment system today. History itself, the rule of law, they're under direct attack like we've never seen before. And we know this, we've seen it. We all see it, and it's unacceptable. Our need for hope and perseverance could not be any stronger than it is right now. It could not be any more acute. We can't afford resignation of any kind. I talked to a friend the other day who said to me, given all that was happening, he had moved on to the acceptance stage. Because what was the point of fighting this anyway? First I thought, oh, do you not understand Dr. Kubler-Ross? Our values and our principles, they're not dead. We have to fight for what we believe in. You took these capital cases because you knew what would happen if you didn't. They would go to an Alabama lawyer who'd get paid $1,000 for the entirety of the case, however many years it took, or a Florida lawyer on the registry who would miss the statute of limitations, as has happened over and over again, stunningly often. You took the case because you needed to, and you gave your clients hope when the odds were really bad, because the alternative was unacceptable. We need that now from all of us in very big and very small ways. Don't let anybody tell you it's impossible to make a difference. We know better. Even if we don't have the roadmap, even if we don't have a blueprint, we in this room have the skills, we have the resources, and we have the imagination. This country can't afford our despair any more than our clients could. You have been very kind to listen to me, rant, and to give me a recognition that's really on behalf of what a lot of people have done. But I can't leave without first noting the very enormous debt I have to Steve Wright, to Brian Stevenson, and to George Kendall. I met them back before quite a number of you were born, and I luckily still get to work with them today. It was a dream come true in my 20s to find people who were really smart and were committed to working against racial bias and poverty. It was a dream. And they were willing to bring me along with it. I can still picture my office in Walton Street in Atlanta, where there were roaches that were like this big, Steve. It was like, I can still picture that too. Standing in my office, which was Robert's office, puzzling out how we were gonna, with Brian, actually puzzling out how we were gonna present our Batson claim to the court for our client who had had 3 juries from which every Black person was struck, so that his competency, his guilt, and his sentencing were all done by all white juries. It was a thrill to get to strategize like that, and it still is. I feel extremely lucky. I just didn't know then where it would lead. I want to thank the staff of the 2255 Project, some of whom, former and current, some of whom are here: Benef Shamarzada, Jenny Osborne, and Elizabeth Luck. And a little bit of Paresh Patel. For working with me and for the work they still do. And the people who've left our project are still busy working on behalf of indigent defendants. Major gratitude to the ABA for doing this. You have found counsel for me in the past over the years, and I hope you can keep your doors open and keep helping the men and women that you have over the years. Let me close with a thank you to all of you who keep fighting, and not just on the Capitol fronts, despite what people say to you about the odds. We're here today because many of you feel it's the right thing to do and had hope, however small that kernel or however deeply buried, that you could succeed. Let's together hold on to that hope and continue to fight, because we're very much needed now.
Three, two, one. One more. 3, 2, 1. Good, thanks.
Wow, tough act to follow. Fortunately, we have an extraordinary keynote speaker who will conclude our programming this evening. And that is Christina Swarns, the Executive Director of the Innocence Project, a remarkable practitioner, advocate, and justice warrior in her own right. If I were to try to describe all of Christina's many remarkable accomplishments and accolades, we would be here until late in the evening. The short version is that she has served as the Litigation Director and Criminal Justice Project Director at the NAACP Legal Defense and Education Fund, as the President and Attorney in charge of the Office of the Appellate Defender in New York, as the winning advocate before the U.S. Supreme Court in the noteworthy case of Buck versus Davis, 2017, and currently as the Executive Director of the remarkable Innocence Project. We are anxious to hear from you, Christina, so please come up.
All right, thank you so much, Ted, for the kind introduction, and thank you to everyone at the ABA Death Penalty Representation Project for inviting me to give this evening's keynote address. I would like to first take a liberty and extend my congratulations and praise for my friend Ruth Friedman on her extraordinary career. There literally is no chapter of my professional life that does not include Ruth. I have benefited from her friendship, her wisdom, and her strategic brilliance more times than I can count. And I will always cherish, Ruth, memories of the annual gathering of the Whistling Swans over goldfish and wine. So with that, I have to start by acknowledging the fragility of the moment that we are in and the very real challenges that we face as a nation, as a democracy, and as a legal community. All of us are feeling vulnerable and wondering whether and to what extent we can continue to rely on the norms, the laws, and the systems that kept us safe. It feels like the foundation that we previously took for granted is suddenly deeply and profoundly unstable. This feeling, which is pretty new to many of us, is tragically and painfully familiar to the people represented by the Innocence Project and all of you, the firms that are recruited by the ABA Death Penalty Representation Project. For better and for worse, so many of our clients, and I'm now going to quote and paraphrase Eddie Glaude of Princeton, had the privilege of growing up in a tradition that didn't believe in the myths and legends of American exceptionalism because they had to bear the brunt of them. Notwithstanding the constitutional guarantees of due process, of a fair and speedy trial, of equal protection under the laws, and of the effective assistance of counsel. And despite the prohibitions on cruel and unusual and excessive punishments and unreasonable searches and seizures, time and again, the norms and the laws and the systems of our country have completely and spectacularly failed. I'm thinking of Marcellus Williams. Mr. Williams was an innocent Black man who was convicted of the murder of a white woman in Missouri. He was condemned to death, even though no DNA evidence connected him to the crime. The trial prosecutor used peremptory challenges to exclude Black people from service on his jury. The two eyewitnesses who testified against him were paid for their testimony, and Mr. Williams received shockingly inadequate assistance of counsel. On September 24th of 2024, Mr. Williams was executed. I'm also thinking now of Robert Robertson. Mr. Robertson has spent more than 20 years on death row in Texas after being wrongly convicted of the murder of his daughter, a crime that never occurred. A missed autism diagnosis fueled erroneous assumptions about Mr. Robertson's demeanor. The prosecution relied on a diagnosis that was never scientifically validated and was subsequently discredited. Experts have concluded that Mr. Roberson's daughter died of natural and accidental causes and not homicide. Nonetheless, Mr. Robertson was scheduled for execution on October 17th of 2024. He received a stay after an extraordinary bipartisan group of Texas legislators intervened to prevent a grave and irreparable injustice. But Texas has rescheduled Mr. Roberson's execution for October 16th of this year. Neither Mr. Williams nor Mr. Robertson had the privilege of believing in the myths and the legends of American exceptionalism. Instead, they are and were members of the communities that bear the brunt of its failures. They're members of the growing community of innocent people who were convicted of crimes they did not commit. The Innocence Project has freed or exonerated more than 250 people since 1992. But the National Registry of Exonerations has documented more than 3,700 exonerations in this country since 1989, including 200 people who were exonerated, nearly 200 people who were exonerated from death row. And researchers estimate that almost 6%, up to 6% of the prison population in this country is innocent. Mr. Williams and Mr. Robertson are in the community of people who face criminal prosecution based on evidence that we know causes wrongful convictions. We're talking about false and unreliable forensic evidence, cognitive bias and tunnel vision in investigation, incentivized witnesses, racial bias, ineffective counsel. They're members of communities that are disproportionately impacted by wrongful conviction in the criminal legal system overall. People of color, people with disabilities, people who are poor. And I appreciate, because of my role, all of the talk of innocence this evening, but I have a 30-year career and only 5 years of it has been spent at the helm of the Innocence Project. And so I have to say, I need it to be clear that the fissures in the legal foundations in our country's criminal legal system are not just grounded in innocence and not just about innocence. Every day, people go before our nation's courts with compelling and meritorious claims of injustice that are never heard or acknowledged. As you may know, as you heard, before I joined the Innocence Project, I represented a man named Dwayne Buck, who was condemned to death in Texas after his own lawyers presented evidence, an expert that told the sentencing jury that Mr. Buck was more likely to commit criminal acts of violence in the future because he is Black. In Texas, a jury finding of future dangerousness is a prerequisite for a death sentence. Because the prosecution didn't actually have other evidence to prove that Mr. Buck was a future danger, it turned out that the defense expert testimony is the factor that wound up supporting this prerequisite finding, and that is how Mr. Buck was sentenced to death, because he is Black. Needless to say, I argued to the Supreme Court that our Constitution and the rule of law does not allow an execution based on an immutable characteristics like race. And fortunately, right, Chief Justice Roberts, writing on behalf of a 6-2 majority, agreed, and he declared the death sentence unconstitutional with sweeping language. Our criminal law punishes people for what they do, not who they are. And when a jury hears expert testimony that expressly makes a defendant's race directly pertinent on the question of life or death, the impact of that evidence cannot be measured simply by how much airtime it received at trial or how many pages it occupies in the record. Some toxins can be deadly in small doses. This decision is rightfully celebrated for the sweeping language that the court used to denounce the racist stereotypes in this capital case. But it's important to know that this expert testimony, this patently false and racist expert testimony, was apparent on the cold record of Mr. Buck's trial, right? It's in the transcript. But Mr. Buck spent 20 years on death row. And the United States Supreme Court is the only court to have ever ruled in his favor. Before I entered the case, when I was at LDF, in 2011, we entered in 2011, Mr. Buck has spent 14 years unsuccessfully appealing his death sentence and conviction. And on my tenure, in my watch in the case, between 2011 and 2017, my colleagues and I presented appeals on his behalf to the trial court, to the Texas Court of Criminal Appeals, to the United States District Court for the Southern District of Texas, and the United States Court of Appeals for the Fifth Circuit. All of them were prepared to allow Mr. Buck to go to his death, even though the record, according to Justice Roberts, supported making a decision on life or death on the basis of race. So Mr. Buck certainly bore the brunt of myths and legends of fair and equal justice in this country. But this is not a story, like Ruth said, of just loss and sadness. It's especially important in moments like this of national turmoil, the hardest moments, to be reminded of the ways in which all of us and organizations like this one, the ABA Death Penalty Representation Project, buttress the promise of our democracy on behalf of those who are most likely to experience its failures. I had Holland and Knight with me through all of the steps into the Supreme Court in the pivotal litigation of Mr. Buck's case. They helped ensure that we got this sweeping condemnation of race as dangerousness evidence. Brian Cave was integral to everything that the Innocence Project and the Midwest Innocence Project did to extend the life of Mr. Williams, to make him a household name, to fight for the justice that he deserved and was promised. They were with us as we litigated an evidentiary hearing and drafted appeals from the denial of that petition to the Missouri Supreme Court, and later the cert petition and stay motion in the United States Supreme Court. They led the civil lawsuit we filed against the governor of Missouri after he unilaterally dissolved the board of inquiry that was investigating Mr. Williams's innocence, and that allowed for the setting of an execution date. Skadden Arps is on more cases in my office, I think, than any others. And we have a team of Skadden lawyers by our side right now as we fight for the life of Robert Robertson. They're working with our team around the clock to get a stay of execution. They're helping to drive every aspect of both the state and federal litigation and the complex communication strategy. It was John Lewis that reminded us that when you see something is not right, you must say something. You must do something. Democracy is not a state, it is an act. And each generation must do its part to help build what we call the beloved community, a nation and world society at peace with itself. This is the heart of the work of the ABA Death Penalty Representation Project. I've had the honor of working with and benefiting from this organization all but the first 3 years of my career. I think this organization first came into my awareness when I became an assistant federal defender in the Capital Habeas Unit in Philadelphia, and we needed lawyers to represent people who were sentenced to death in Pennsylvania. Thereafter, they were always there, not just connecting people with lawyers who needed representation, people who were under sentence of death, but also providing formal and informal guidance and training to those of us who are handling those cases, including around the ABA guidelines for the appointment and performance of defense counsel and death penalty cases, which is, of course, the Bible for anyone that does this work, and also the state death penalty assessments. It is a particular honor, therefore, to speak here tonight, not just to honor Ruth and all of the firms that have been honored this evening, but also to remind us, as Ruth just said, that it is in times like these, the ones we're living in right now, that this kind of organization reminds us of our own power to shape and responsibility to shape the democracy that we live in. Thank you.
Thank you so much, Christina. I was pretty sure you wouldn't disappoint, and you didn't. I have to thank a couple more people. Emily Olson-Gall is not here this evening, the staff director of the ABA Death Penalty Representation Project, because she is home taking care of a new addition to her family. But she is a stalwart with respect to this work and the lifeblood of the DPRP, and we couldn't do what we do without her. And Abby Crick and Alex Campbell are here and have done a really wonderful job pulling all of this together, particularly in Emily's absence. So thank you guys for that. And thank you again, Susie, for hosting us in such a really stylish and wonderful fashion. And if any of you have been inspired to do so, please feel free to scan the QR code on the programs that are scattered around the room and support us to the extent that you feel necessary or appropriate. It's all going to these really, really critically important causes. So with that, I think we have the room for a little bit longer. So please feel free to mingle with colleagues and friends. And thank you again for being here.